campus of North Idaho College and today's broadcast of the North Idaho College Public Forum. The crew is comprised of North Idaho College television students. Your moderator is North Idaho College political scientist Tony Stewart.
Good afternoon, ladies and gentlemen. Today we wish to discuss with you two laws that were passed some years ago by the Congress of the United States that have had very significant impact upon our country. The first one was the Freedom of Information Act that came into being in 1966, and the second one was best known as the Privacy Act of 1974. Through those two pieces of legislation, two things have happened, in particular in this country. First of all, we the citizens have obtained a lot of information that was classified from our federal government. And secondly, you the citizens of this country have had more protection in relation to your privacy, and also to be able to know what was in records of federal agencies about you after that law was passed. We're very happy to welcome to our program Mr. Frank Needham, who's had a background in this and will share his thoughts on those two laws. Mr. Needham holds a criminal justice degree from Portland State University. He also holds a BA in management and accounting from Boise State University, and is now working on his master's in business administration from the University of Idaho. Mr. Needham has particular expertise that he can share with us due to the fact that he was a member of the FBI for 4 years, stationed or located in Washington, D.C. and Portland, Oregon. He has served in the Air Force, and then following that particular experience, he went to work for the IRS, where he was employed for 5 years. Presently, he is an accountant with the Hagedorn Corporation in Coeur d'Alene, Idaho. Mr. Needham, welcome to our program.
Tony, thank you for having me.
I'm very happy to welcome to our panel to question our guest today. First of all, Mary Lou Reed, who is a permanent member of the panel, has been with me for many years, and she holds a baccalaureate degree from Mills College and did her graduate work in religion at Columbia University. And I also want to welcome Brian Scott, who is a sophomore majoring in pre-med at North Idaho College. Welcome, panel.
Thank you very much.
I would like to invite Lou Reed to start the questioning.
Frank, let's start with the Freedom of Information Act. Could you give us a little bit of a background of what are the reasons behind the enactment of this particular act? What were the government agencies doing that perhaps promoted the need for this particular legislation?
Ms. Reed, you're presuming that I understand congressional intent when they try to do something like this. The understanding that we had from the FBI's viewpoint, which is the agency I was associated with at that time, was that there was a need for some monitoring process so that the agency was protected in the information it collected, that the citizen was protected in the information that was collected and then used in law enforcement. The Freedom of Information Act provided that the FBI could collect data that was only to be used in the enforcement of statutory law created by Congress as well as Justice Department. Whereas the citizen had to know that the information he provided as a third party was protected, not only from the identity situation. If his testimony was provided as a secret witness, he would be protected that way, but also from pecuniary damages if it was in a lawsuit or litigation in regards to corporate matters or bank embezzlements or matters along those lines.
Well, how does this work? Say if I'm an ordinary citizen, I understand perhaps that the FBI may have some information on me. How do I go about calling into action the Freedom of Information Act, and what is the procedure?
Okay. As a citizen, a private citizen, and there's a distinction that we'll make here a little later about the difference between a citizen who is private and a citizen who is corporate. But as a private citizen, you have to go to the agency. You have to tell them who you are, the information you're requesting, and why you're requesting it, and what use you have for the information. Then the FBI has to respond to you within 10 days as to a disposition of how they're going to provide the information to you. They do have the right at that time to tell you that they will not provide it to you, depending on what use that they had of that information. If they do that, you're allowed to go to a judicial process which has to be responded to in 35 days. And once the judicial process has been decided, you either get the information or you don't, and then you have to take it up through the Court of Appeals on up to the Supreme Court if it's that type of question.
Well, this sounds like it's very, very complicated and a lot of red tape, and so it doesn't really work.
It works, but it also protects the agencies. It's still a bureaucracy in movement. Very slow, very sluggish. They're protecting themselves at all steps of the process. But the citizen now does have the ability to get information where they couldn't before at all.
Okay, I'll come back to this in a minute after
Brian Scott.
I'm going to kind of play both sides of the coin with my question here. First of all, it's been said that the Freedom of Information Act is unconstitutional and that it gives a constitutional right to the judicial branch that should, in fact, belong to the executive. How do you combat that? How do you feel about that?
Brian, you hit me way over my head because I am not a lawyer. I don't pretend to know law in that respect. My own personal feeling and from, again, the agency viewpoint is someone had to control it, and the best agency is the one where there was a proceeding and an opportunity for relief, not only for the agency, but also for the citizen. And the only branch that provided that was the judicial branch. It couldn't be the branch that created law, and it could not be the branch that enforced law. The only, or excuse me, not enforced it, but also created law.
In authoring the Freedom of Information Act, what were some of the wrongs you were trying to get rid of, some of the wrongs in withholding information from the public?
It was a policy of most agencies to classify the information that they had garnered from either private or public sources to a point that the agency was protected. So if at any point in time that an action or a litigative issue was brought to the courts, the agency was always covered because they said we cannot reveal our sources, and that was the end of the issue. It did not satisfy the private citizen or the corporate citizen. It did not provide a method of relief for them. So what the Freedom of Information Act tried to do was say, use reasonableness, classify only that information that can be detrimental to the security of the country or to the individual in a life and death situation.
If we may proceed with that, Frank, I noticed in the copy that I have of the Freedom of Information Act that, as you just got through indicating, that information is available to the public and cannot be labeled confidential or secret unless it falls under one of 9 exemptions. And you've already addressed that somewhat. I notice here in those 9 exemptions that obviously that anything's in dealing with the national defense or foreign policy that's critical to secure the country does not have to be released to individuals or organizations. Would you take a little more time to elaborate upon what all those 9 exemptions are? I don't ask you to go through all 9, but give the audience a little bit better idea of what is not available if they were to go to the government request to receive that information.
All right, Tony, I would like to preface the remark in regards to, again, what I did.
Yes.
There were many cases where we had an investigation going on the behalf of the government or a state or a local law agency where we were securing data that would lead to a conviction of an individual or a group of individuals. The data that we would secure quite often would come from a third-party source, whether it's a private citizen or the corporate citizen or a public agency. What happened was that as soon as we got the information, we put a tag on it that said, you know, this is confidential, confidential file. We are not going to release this to anyone for any purpose. Unfortunately, there were leaks in the government at the time. The information still got out. It became harmful to individuals, to agencies, to the third parties. Convictions were lost. And so what they said is that if we are going to label it confidential, we have to have a procedure within the agency that assures that it will be confidential. So we set up a review process at the FBI, the national office, at the field office levels that created confidentiality and secret classifications that would not allow the information to be leaked.
In the experience you had, and I know that's what you dealt with, that I was referring to something that would be, in some cases, beyond your agency, such as the defense, and foreign policy would be in other agencies probably. But I also note in the copy that I have that about your own personnel and so forth, that you would have records, I would assume, on the IRS employees or FBI employees, their personnel records, their medical files. And in other words, there is some confidentiality there, too, of information that cannot be released. This is almost reverse process of privacy. In other words, employees have right to privacy, too, and some of those records are not available to outside individuals or groups.
Well, quite often it was even further true to say that the employees didn't have access to their own files within the agency. Quite often there was an evaluation process by supervisory staff for either a promotion situation or for a transfer situation where either derogatory comments were made or comments that were supposedly off the record, but as all agencies do, they recorded anyway. And so those records now became confidential to the point that the employee couldn't find out what was said about him. Just one more case where the bureaucracy was protecting itself to the expense of the individual that was actually employed or using the bureaucracy.
So we're really talking about two things. One is protecting that individual to their privacy for the general population, but at the same time also giving that individual a chance to know what others may have gathered on that particular person inside government.
That would be correct.
One final thing, we'll turn to the panel, and that is concerning the Privacy Act. I think we should make note, should we not, that when individuals have a right to find out about their records, that there is some special protection for the FBI or law enforcement or CIA or Secret Service. What I'm attempting to say, not that I'm agreeing necessarily with this, but they have more power to keep things secret about individuals in a file than is true of other federal agencies. Is that not correct?
I agree with one stipulation, that the information that they're protecting is directed towards an investigation.
If not, then it would not.
If not, they have probably less, because they are such a focal point of controversy because of the nature of our tax structure, because of the nature of enforcement agencies not being a popular thing to have in society, but they're necessary. So they become more appealing to those groups of people that want to push an issue, to make an issue become a public spectacle.
Ladies and gentlemen, if you've joined our program in progress, our guest is Frank Needham, who worked for the FBI for 4 years and the IRS for 5. He's now in private business, and he's discussing with us the Freedom of Information Act and the Privacy Act. We shall continue the questioning with Lou Reed.
Well, I'm really intrigued with your talking about how the bureaucracies actually were protecting themselves. And I suspect one element in this is the rivalry between Congress and the agencies. What does the Freedom of Information Act say about withholding information from Congress? What kind of information can agencies refuse to give to Congress?
Are we directing this towards Mr. Watt?
Well, we could. Is this the law that applies? He will be if he's held in contempt, it would be under this particular act.
I don't want to cop out, Mrs. Reed, but you're asking me a question that hasn't even been decided in the courts of law.
Oh, all right. But is there something? There is. The act does deal with what information can be kept from Congress, and what information can.
It does specify that information that is necessary to the creation and the maintenance or the actually termination of regulation that is legislated by the congressional body has to be made available to them.
So it's really how it pertains to legislative matters.
It does. Unfortunately, Congress as well as lobbying organizations tend to go after more information because it makes their case look better.
So again, you're suggesting that there are abuses on both sides.
There's definitely abuses on both sides.
Do you think there really is justification for keeping information from Congress on anything? I mean, it's very hard for me to imagine what grounds one should keep information from Congress when almost everything is subject to potential legislation.
I'd like to cite a case, if I might.
Mm-hmm.
I won't cite dates, and I don't remember them that well, But in the case of the U.S. against Genovese, who was reputed to have been a mafia or a Cosa Nostra leader back in the 50s and 60s, he was being investigated by several of our federal agencies, including IRS and including the FBI. They are doing it independent of each other, as well as working on task force under the Attorney General's auspices. There was information that was leaked to a couple of congressmen that made them become interested because they thought that the way that the investigative process was being accomplished was abusing the powers of the agencies. We're talking about wiretaps. We're talking about invasion of privacy, going into the actual environment such as the premises and getting records to make the case look better if it ever got to the court system. So they requested from the agencies that how the investigative process worked be made available to them for the subcommittee that they represented. Both agencies independently again said, no, we will not provide that information to you. We will provide the information that dictates how we respond to an investigative matter that's brought to us by either the Attorney General or by a state agency. But we will not tell you what we have gathered and how we have gathered it, because they said it had nothing to do with how the regulations were created. And the Supreme Court took up the issue and agreed.
Substantiated. Thank you.
Brian Scott.
From what I've been hearing about the Freedom of Information Act right here in this little conversation, it seems to me like it's rather vague, is it? Can you read a lot into it?
Brian, I think that's a very good statement. I would be tempted, and I say this from a very personal and as an individual citizen and a private citizen, that it was created vaguely. Again, remember, it's not your congressmen and women nor your senators who write the law. It's still the bureaucracies who write the law and present it to them or their staffs. And their staffs are influenced greatly by what is happening at the agency level. The agencies still had to protect themselves. They also recognized the need that the public fervor was such that they had to do something, even if it was just something for show.
So,
the Freedom of Information satisfied show.
So if a government agency really wanted to withhold some information, the odds would be with them in doing so.
Yes, but they'd have a lot tougher sledding doing it.
Okay. Thank you.
I would like to get a point across to the audience, however, and that is that since these laws have gone into effect, there have been a lot of results from your work in two agencies. Is it not correct that with the adoption of the Freedom of Information Act, that there's been a tremendous amount of material that would not have become public that has become available to the public because of that law?
That's correct, Tony. Unfortunately, though, I wonder if the volume of information equals the use of the information or the effectiveness of having that information. Case in point, currently, I wish I remembered the folks' name that just went to court using the Freedom of Information defense to get the audit procedures that IRS employs with the TCMP program.
That was the Longs out of Seattle.
The Longs, that's correct. Thank you. Mrs. Long felt that the procedures IRS used to audit their business in Seattle were not constitutionally correct as well as procedurally correct. But she couldn't prove that with the available information. And so she decided that she'd talk to an attorney who ended up being several attorneys down the road before they became interested in fighting the issue with IRS. And they employed the Freedom of Information as their doctrine. And to this date, she has won twice, but she's lost because she still doesn't have the information. And even if she does get the information, the time processes that have been involved are so long that by now I'm sure that the agency has changed their particular computer procedures, their statistical model making that made an audit possible under the program.
Would you agree that the fact that this is in a mechanism now, and that agencies know that things they do may become public, that it may, in that mechanism itself, restrict them somewhat or cause them to hesitate to do certain things?
Well, let's say they become more sophisticated. I think that what they're doing is they're recognizing the need that they still have got to do their job. We all recognize that for this country to operate in the vein that it has, that our freedoms be as broad as they are, even with as large of a population base, that the agencies still have to do certain things that are either counter to social pressure of the times or vague in whether they're right or wrong. And there's a lot of gray areas in any type of law that's written. So the agency said, all right, if we're going to do it, we have to think it through far more thoroughly, because what happens if we take a gray area and we take the wrong stance from what is popular at this time, and we have to defend it later? Because we saw a lot of our public officials go to jail here in recent years because they were wrong.
One final thing before we turn to the panel. I was just wondering, under the Privacy Act, if we really had not slowed down the interchange of data on people from one agency to another one. For example, I have before me a statistic that 858 data banks in 54 federal agencies existed at the time of the adoption of this law, and that there was 1 1/4 billion records that were known in systems. And of that number, 457 of the data banks analyzed had no explicit statutory authority for their existence from Congress. With that information coming out and then the law being passed, are agencies more careful about, when getting requests from other agencies, giving someone their record? And did these statistics not justify such a law?
Yes, agencies are more careful. Procedures are well documented. Again, they're protecting themselves. No agency wants to be called on the carpet and find out when they're called on the carpet, they're going to call someone else on the carpet. So that the exchange of information formally has become more tedious, has been better documented, and better controlled. Informally, the exchange of information still occurs. It's necessary to perform a lot of the agency's works. I'd like to address the other part of the question in regards to the maintenance of files. At 1968 through 72, when I was with the FBI, part of that time was spent in Washington, D.C., and part of my functions back there, even though I was a youngster, I was allowed to join an audit team. The audit team worked in conjunction with GAO audit procedures, and we are auditing how the FBI maintained records. The FBI maintained not only conviction records, but they also maintained fingerprint files, which was not statutorily or procedurally granted them the right to do. That was just an internal documentation that occurred back in 1927. They maintained ownership files on every type of personal property you can imagine that were not statutorily allowed or procedurally allowed. It's just something that occurred through the years. They actually had 41 different ways of recording information about an individual that were not allowed, and there was only one that was. Yet their conviction rate, their success at being the agency that they were, was phenomenal because of those files.
Lou Reed.
Frank, what are the major invasions of privacy that you think citizens should be concerned about? Governmental invasions.
The most important, I would say, where the abuse tends to be the greatest is in financial records. And to my limited knowledge at this time, there is still a need for clarity in what information of a financial or economic base can be provided or should be solicited by the agency from the businesses, from individuals, from other public agencies. So much of our lives hinge on economic considerations, and the government still has a right, exempt from the Privacy Act, that they can get this information very easily. And if anyone wants to make a noise about it, There is a subpoena process, which all it is having an enforcement agent go back to his respective office and draft out a form and bring it back and say, here, you're subpoenaed for the documents.
Computer technology has brought us a lot closer to 1984. Is that right?
At times it scared me, Lou, while I was working for him, but also it made, hopefully, if you had a professional out in the field enforcing the laws of the country, no matter what endeavor they are with, if it's tax law or if it's criminal law, those people were trained and educated in such a way that they did it correctly. There are abuses. Some of them are accidental, some of them are not.
Brian Scott.
What I'd like you to do for me, Mr. Needham, is take the Privacy Act and set it right next to the Information Act. And do they operate totally independently of each other, or is there some interplay there?
Wow, Brian. That's a tough one, because remember that the Freedom of Information Act is really a series of acts. It came through a long process of determining what information was going to be made available for what reasons. Privacy Act is just the opposite, because it says that the citizen is entitled to certain protections. And even though the federal agencies were allowed to collect the data, those data files, those data records had to be determined to be correct. They had to be determined that they were proper, and the only one that could make that determination was the individual. So the Privacy Act allowed the individual to check if they were, and if they weren't correct, to force the agencies to correct them, or if they shouldn't have been there in the first place, to delete them with no prejudice. Freedom of Information Act says to the citizen that they can go in and find out what procedures were used to collect them. So that really is your difference. One protects the citizen by giving him or her the opportunity to go back and correct data, and the other one says, how did you do it?
I'm afraid I must interrupt at that point. We're out of time, and Frank, I want to thank you very much. You've been extremely informative to us on these two laws, and I'm sure our viewers know much they did not know before. Thank you very much.
Thank you, Tony.
I express my appreciation to the panel for outstanding questions. Ladies and gentlemen, our guest has been Frank Needham, who is an accountant with Hagedorn Corporation in Cortland, Idaho, but prior to that, he worked for both the IRS and the FBI, and he's been here to discuss the Freedom of Information Act and the Privacy Act. I hope you've enjoyed our program and that you will be with us again next week at this very same time, when again we will discuss what we believe to be an important issue. Please have a good week. I am Tony Stewart.
The North Idaho College Public Forum can be seen at this same time each week over this station. This production was videotaped earlier by a North Idaho College student crew for viewing at this more appropriate time.